Before we start today's program, I would like to share some housekeeping information. First, this is not a CLE accredited program. Second, you may submit questions at any time during the program using the Q&A function at the bottom of your screen. After the program, you can send your questions and comments to crimjustice@americanbar.org. Finally, this program is being recorded. Welcome to the intersection of the criminal justice system and people with mental disabilities, sponsored by the ABA Criminal Justice Section. And now we will hear from Criminal Justice Section Chair, Kim Parker. Kim?
Yes, hello everyone. My name is Kim Parker, and I want to welcome you to this very important webinar. We have an outstanding group of panelists to discuss the intersection of criminal justice and people with mental disabilities. As chair of the Criminal Justice Section, I also want to invite each of you to join us and become a member of the ABA Criminal Justice Section, because there we develop policy and standards and educational programming around emerging issues in criminal justice. We look at how we're doing business and what we can do to reform and improve our legal system so that those impacted receive fair and just treatment. This year commemorates 100 years of our work at the ABA Criminal Justice Section to improve criminal justice. But there's always much more to do. In fact, the challenges that we face presently to rectify inequities are very real and very present, and our work must persevere. That's why we need you. At the ABA Criminal Justice Section, we collaborate and listen to diverse voices and thoughts from prosecutors, defenders, judges, academics, and anyone interested in the improvement of criminal justice, so we can arrive at better solutions. Our members come from all parts of the United States and around the world. So those of you, especially today, who are interested in mental health and criminal justice intersection, I want you to know that we have a dedicated mental health committee that serves to provide resources on issues related to people who are both living with mental illness and involved with the criminal justice system, including the rights and protections of inmates and pretrial detainees with mental illnesses, issues surrounding voluntary and involuntary treatment. We consider resources available in the prosecution and defense of persons with mental illness, the role of judges in cases involving persons with mental illness, and advocate for diversion and reentry programs where appropriate for offenders with mental illness. Our mental health committee works with other criminal justice committees inside our section, as well as other ABA entities such as the Commission on Disability Rights and Section of Health Law, as they relate to arrest, detention, treatment, sentencing, release, and reentry of persons with mental illness. Also, currently, we are working on the revision of our mental health standards in criminal justice. The criminal justice of the ABA is a place where we want you and your voice, and it is a place where you can make a difference. But now, I would like to turn this space over to Elizabeth Kelly. Elizabeth is a member of our Criminal Justice Section Council. She's also a nationally recognized criminal justice defender on both sides of our nation, East to West Coast. But furthermore, she is an esteemed author and has produced several books on mental health and criminal justice topics. Thank you, Elizabeth, for agreeing to moderate this panel and putting it together. And so now I'll turn it to you to introduce your panel.
Thank you, Kim. And I want to thank you for your leadership of the criminal justice section during a very difficult and unpredictable year. And I also want to thank you for recognizing how very important the intersection of mental disabilities and the criminal justice section is, and encouraging this panel to go forward. It was originally scheduled to go forward in person in Kansas City this spring, but unfortunately, because of the pandemic, it had to be canceled. But nonetheless, it's going today, and perhaps in a way that's a blessing, will be recorded and arguably would have been. For all of our listeners, the ABA has a very proud tradition of educating all players within the criminal justice system about the plight of people with mental disabilities. And by that, I mean educating judges, educating prosecutors, educating criminal defense lawyers. It is inevitable, wherever you are in the criminal justice system, you will encounter someone with a mental disability. We estimate that approximately half the people in our nation's jails and prisons have some sort of mental disability. And by mental disability, I mean a mental illness, or I mean an intellectual or developmental disability. And Dr. Woods and others on this panel can talk about precisely what those terms mean, and sometimes what we call co-occurring disorders, that is to say the presence of one or more. Very briefly, the way this panel is going to operate is I am going to throw out a very general question to each of our panelists, and they are going to have a dialogue with us for approximately 10 minutes. And at the end of that time, I'm going to open up the floor to questions, and many of them, I'm sure, would be happy to respond in whatever way is appropriate. So without further ado, we are going to start with Dr. George Woods. Dr. Woods is a forensic psychiatrist based in Oakland, California. He is one of those people who has a resume where when you look at it for the first time, you think, no, this can't be true. This man is making it up. But in fact, he is not only a nationally recognized practitioner, he is a prolific author, and he is the past president of the International Academy of Law and Mental Health. So thank you for joining us, Dr. Woods. And the first question I'm going to ask you is, the terms competency and sanity are often used within the criminal justice system interchangeably. Are those two terms the same? If not, how are they different? And are the legal definitions of those two terms the same as the mental health definitions?
Well, first of all, thank you for having me, Elizabeth. It's always a pleasure to talk with you and to talk with others about these issues. You're so right in terms of the impact of mental health on the law, and I think it's important to, before I go into exactly that question, to just kind of follow up in terms of your statistics. You know, the three largest psychiatric facilities in the country today are the LA County Jail, what was Rikers Island, and Cook County. These are the three largest psychiatric facilities in the country today. And that does not include substance abuse. I'm just talking about people that have symptoms of mental illness. So we have significant numbers of people in our jails and prisons around the country that have symptoms of mental illness, that have symptoms that really have changed over time. And when I talk about symptoms of mental illness in 2020, we're not just talking, and frankly, we're not talking as much about hallucinations and delusions, those types of symptoms that people often attribute to psychiatric disorder. They're really talking about problem solving. They're talking about being able to understand. They're talking about understanding social context. Being able to pick up social cues. So cognition of how the brain works or doesn't work really identifies many, many more of our psychiatric patients and clients in the prison setting than the old thinking of schizophrenia or bipolar disorder having breaks with reality. And that's where the question of competency and insanity come up. Neither competency nor insanity are psychiatric terminology. Neither competency nor insanity have a place in the psychiatric language. These are legal constructs that are informed by mental health. And not only mental health, but neurological health. So when we think of competency, we think of someone that is able to handle themselves to some degree in a courtroom, or to handle themselves in a legal setting. And the real question of whether they are able to understand the role of the attorneys, the role of the jury, the role of the judge, their ability to help with their case, to help their attorney, their understanding of what's in front of them, what charges they may be facing, what the crime is they're being charged with, what are the options in terms of defenses. You know, when we talk about competency, it's really being able to handle yourself within a courtroom setting. And if for some reason or another, you're not able to do that because of some brain problem, because of some psychiatric problem, if in one of those areas you're not able to really meet what is in fact a very low standard in the United States, then you can be found incompetent. So if for some reason you don't want to get along with your attorney, or you just don't like your attorney, or then that's not being incompetent, right? It really has to be based on some psychiatric, neurologic defect that lends itself to your inability to rationally assist, that lends itself perhaps to your inability to really understand what the roles of the various court members are, or your inability to move along with the trial and help yourself and help your attorney understand what the processes are within the courtroom. Competency is very different than insanity. Insanity is really, are you able to understand what you've done? And are you able to understand the reasons why it occurred? So, so insanity is if this act was caused by you not being aware that this victim was a person, you not having a clear understanding of right from wrong, and that can only be based on, again, a cognitive deficit, a brain problem that somehow impairs your ability to understand that what you were doing was wrong. In different jurisdictions, we see the words appreciate and understand, and they're often used interchangeably, but they're not. Appreciate has a much different and really a much more psychiatric view as opposed to understand, which is really much more direct. Again, if you know what's wrong, but in fact choose not to do it, or if you, then that's not being insane. And I think both in terms of competency and insanity, very, very few people in the criminal justice system are found incompetent. Very, very few are found insane. Less than 2% of people of serious, serious crimes even attempt an insanity defense. So it's much, much different than what we hear in the popular culture.
Thank you for that wonderful explanation, Dr. Woods. Over the years, undoubtedly, you have worked with countless prosecutors as well as criminal defense lawyers. How can attorneys from both sides do a better job in working with the mental health expert? In other words, how can they best facilitate the relationship with the expert?
Well, I think you have to understand what the role of the mental health expert is, and that is to help the legal team, be it prosecution or defense, understand what's going on. Experts don't make a case. Experts don't win a case, but experts can lose a case. And it really, in my opinion, it really is the role of the mental health expert to inform accurately the team of what's going on with that person. And that's long before you come to the legal conclusion. You want to know what's going on clinically. You want to know, does this person have bipolar disorder? I really look at psychiatric disorders in terms of symptoms rather than diagnoses, because one of the things that you said earlier is really very important, and that is psychiatric diagnoses don't occur singly. You don't just have schizophrenia, or you don't just have bipolar disorder, or you don't just have obsessive compulsive disorder. The most common presentation is to have 2 or 3 diagnoses. Trust me, if you have schizophrenia and you aren't aware of what reality is at times in your life, and the world seems unusual to you, you're going to be depressed. And you're
Sure.
going to meet the criteria for depression. And about 40% of people that have schizophrenia are also diagnosed with depression sometime in their life. About 65% of people that have bipolar disorder are also diagnosed with post-traumatic stress disorder. Because if you have a significant mood swing, you have bipolar disorder has a very high tendency to be involved in substance abuse. If you're going around with impaired judgment, there's a good chance that you're going to get in trouble. And this is really where, if you don't look at it carefully, and if both sides, prosecution and defense, don't look at it carefully, you can make, major mistakes. Can I just give you an example?
Certainly, yes.
I think a classic example of this rush to judgment was the 3 strikes law in California. When the 3 strikes law was first developed, it certainly made sense that if someone had 3 opportunities and they somehow couldn't quite figure this out, then perhaps it did make sense from a public safety point of view rather than a public health perspective to have that person isolated from the community. However, as time went by, the last 25 years of the law, what we realized was that given the mandatory sentencing guidelines, if someone actually got 3 strikes, there's an excellent chance they were probably committing some pretty minor offenses to get to that 3rd strike, right? And those first couple strikes were, stealing out of a bologna out of a Safeway, or getting into a scuffle in the street, all of which were looked at as dangerous deals. But we ended up having in our jails here in California significant numbers of people with low-level crimes that occurred often as a mental health issue, crowding our jails. And did they deserve to be there? They certainly had committed crimes. But we also saw that there was a real difficulty and that many of these people had significant mental illness. So I'm not in any way suggesting that they shouldn't have been punished for their crime. But when I look at this population, and now we've seen, Clapper versus Brown and other cases that reflect the fact that high numbers of mentally ill people were incarcerated in our jails.
No, you make an excellent point, Dr. Woods. And in fact, those minor nonviolent crimes like stealing bologna out of a Safeway could have been cries for help.
Right.
And unfortunately, no one heard them. Thank you for that contribution. And now we are going to move to Mark Dupree, who's the relatively new district attorney of Wyandotte County, Kansas. Thank you for joining us. Mark, can you hear me?
I can. Thank you for having me.
Well, thank you for joining us. Mark, you have a very, very difficult job because you, like all prosecutors, like all district attorneys, are ethically bound to promote justice. And that can be particularly challenging in the case of people with mental disabilities, particularly people with mental disabilities who may be charged with very serious crimes, some of which are portrayed and covered regularly in the media. How, Mark, do you strike a balance? That is to say, how do you help this relatively vulnerable population, yet at the same time protect your community, keep your citizens safe?
I would say a couple things. One is that it starts with education. It starts with educating. And many people think when I say education, it's about one, right? The prosecutor, the assistant prosecuting attorneys, the line DAs knowing what mental health is, different disabilities, and so on and so forth. But I start with educating the community. The community has to be educated in concern of what justice really means and how it affects not only the cases, but how it affects the individual lives of the citizens. And so one of the things that we have done is made sure that we've gone out and educated our community members, our neighborhood organizations, in concern of this specific subject and how it is intertwined with the criminal justice system. That's one. The second thing is then, right, making sure that my office is keenly aware of the different options that that each case has concerning taking into consideration a person's mental health and or disabilities. And so we have created multiple different diversion programs as well as alternative courts in our district to assist and deal with this very thing. But it is very difficult because for some people, when you say justice, especially as a prosecutor, or if you hear a prosecutor say justice, we're fighting for justice, that aligns with we're locking somebody up. And so when you don't see that, as a citizen, if you're not educated, that justice does not mean automatically locking someone up, but justice means dealing with the issue that caused the crime to occur in the first place. And sometimes that means getting folks treatment, getting folks assistance, getting folks the help that they need. And in other times that means locking folks up. And not every time does that go smoothly for the community members. Sometimes there's pushback. You know, I don't care what his disability is. I don't care what his mental health is, and they want to see. Sometimes people just locked up. And so it really starts for me with educating the community, educating my line assistant district attorneys, and then making sure that we have alternatives to locking people up. Because the doctor's right. You can look across the country and most jails, specifically county jails, are filled with folks who have some type of mental health diagnosis and or disability. And many times it's because prosecutors do not have an alternative to deal with or to find or try to figure out justice except for putting them in jail.
Mark, you mentioned the word alternatives a couple of times. What are some of the alternatives that you have in Wyandotte County? And what are some of the other alternatives that you'd really like to implement?
So one of the things that we have in Wyandotte County, of course, that I believe others have, is a behavioral health court. In other locations, the name is the mental health court. And so, and with that, when I came into office 3.5 years ago, and there was no behavioral health court, there was no alternative. Thus, folks who were dealing with those situations and diagnosis were not given any type of real consideration except for maybe taking some time off of their sentence. Whereas the behavioral health court now, once the case comes in, we're able to review those cases, review those facts, and then make a determination on if this case needs to be in the behavioral health court, thus dealing with the underlying issues, connecting them with their doctors, psychiatrists, psychologists, getting them back on their meds. You know, one of the biggest issues is that we find is many of these folks who are committing these crimes, especially those lower level ones, they literally don't have the funds to pay for their medication. And so they are diagnosed with some type of ailment and literally just can't afford it. And those are usually the same folks who can't get out of jail because the bond that they have is too much. And so when we talk about how the alternatives are so important, this not having alternatives disproportionately affect the disenfranchised. People who do not have money, and quite frankly, many of the folks who are diagnosed with mental health diagnosis are the disenfranchised. They don't have the funds, and the reason why they're in the system is because they didn't have the money to get the meds or to get the diagnosis or to have the medical assistance or Medicaid, Medicare to go and get the diagnosis that they needed. And so,
Sure.
And so the behavioral health court, and then what we did in our office is we didn't want to wait until after a charge was filed to be able to deal with that. So we created the mental health diversion program, and that allows my office, without the court, without the judge and everyone, to be able to look at the case, look at the facts, and then at that point, before making our charging decisions, to connect with any doctor or therapist that they already have to determine what would be the best outcome for this specific case. And this allowed us to give them contracts with our office that if they are compliant with what their doctors are saying, taking their meds, also giving them the financial assistance through some of those resources we have in our community to get that treatment and to get that help. After a year, then the case goes away, right? Because again, when we're talking about the disenfranchised, when we're talking about those folks who are negatively affected by not having the alternatives to deal with that, we also have to look at, if you put this charge on them or put this felony on their record or so on and so forth, then the likelihood of them being able to get off and under this and go get a job and to become a part of the tax base rather than the tax burden completely decreases, because now they have this on their record. And so for us, it starts on the front end. And if I had a hope, my hope would be that there were more lead prosecutors who think like this, rather than who focus on simply getting a conviction and getting a win. Sometimes that's really good and it's politically palatable, especially during election time. But to do the righteous thing is oftentimes the hard thing. And that means taking your time and finding those alternatives to help individuals like we're talking about today.
No, as you underscore so eloquently, Mark, questions involving people with mental disabilities are tremendously complex. And so often it's a chicken and an egg situation. Final question for you before we move on to Commissioner Casey Clevenger. Many families are frustrated. They have a loved one with a serious mental illness, and they feel that they have no alternative. They are at the end of the road, and they think the only thing that's left is to call the police. But unfortunately, when police come, often bad things happen, whether it's an arrest or, God forbid, a shooting. Can you tell us a little bit about some options that families in Wyandotte County have, and how law enforcement in your county responds to some of these situations, these very difficult situations?
I wish I could give you more of what I'm about to give you, or more than what I'm about to give you. But the reality is, there's not a lot of options.
Okay.
Our law enforcement here in Wyandotte County, I believe last time I checked, about 85% of them have now that CIT training, crisis intervention training, which is good. Many kudos, high five to them, and that's wonderful, because I believe it's a step in the right direction. But unfortunately, our police officers are not psychiatrists. They're not therapists. They're not social workers. They are police officers. And I think one of the biggest issues that we have is having police officers to deal with situations that they are not equipped to deal with. And in many jurisdictions across the country, we know, especially I'm sure the panelists know, that there are some emergency social workers, emergency psychiatrists that go to the scene with law enforcement to assist them to deal with those folks who have these different concerns and issues. And I think that should be the case across the board. Now, that tiptoes into a very, again, non-politically palatable conversation, but there has to be a real conversation on the amount of funding that is lacking to deal with these specific issues. But a lot of that funding is given to law enforcement when they're not equipped to handle it. And so I believe that there needs to be a serious conversation on taking some of those funds and putting them in places where it can actually be fruitful. I believe that the CIT training is good. And here's the thing, it's good so that individuals can walk away. About 2-3 years ago, right next door to us in the county, Johnson County, a young man, he was having a suicidal situation, and they called the police, and within 13 minutes of them being there, this young boy is shot and killed multiple times, backing up out of his vehicle. He was trying to drive away. And so here's the point. Point is, crisis intervention is something that says, how can we figure out to make sure everybody goes home safe? Let's de-escalate. What crisis intervention is not, is the resolution to this. And we need to figure out what that resolution is. And I believe that one of these fine folks on here can definitely give you an answer better than I. But I think that we have to take it out of the hands of law enforcement, let them stick to protecting us and being peacekeepers and de-escalating. But we need someone different than law enforcement going to the scene to deal with something that, quite frankly, they're not equipped to deal with. Thank you for this opportunity, and I hope you got a little bit of something out of my answers.
Well, we got a lot of something. Thank you, Mark. Appreciate. And now we're moving on to the Honorable Casey Clevenger, who is the court commissioner of the treatment court in Columbia, Missouri. Welcome. Thank you for joining us.
Hi, good afternoon. Thanks for having me.
Dr. Woods used the term earlier, problem solving. And that has become a very important term in the past few years nationwide, because a series of problem solving or treatment courts or mental health courts or behavioral courts have opened up. And you have one in Columbia County. Could you tell us generally, what is a mental health court? Who decides who gets in? What are the typical requirements, and what are the benefits for both the defendant as well as the prosecutor or the district attorney, as the case may be, and perhaps victims?
Sure. Thank you, Elizabeth, and thanks to the ABA for having this event this afternoon. I am going to have to ask to go in a different order because following Mr. Dupree is tough, because I think everybody's going to want him to be moving to their jurisdiction. So I'm in Boone County, Missouri, which is Columbia, home to University of Missouri. And we actually have 8 of these problem-solving courts, one of which is our mental health court. And about 20 years ago, our community decided to pass a tax proposition to assist with mental health issues that were arising in the county. And I think that's really important because people must understand that these are community issues that need to be resolved in the community. And so our community recognized that, and their response to it was to put some tax money to help solve these problems. So that is how our mental health court is funded, through a county tax proposition. Our mental health court it's an alternative sentencing court, a problem-solving court. We have a couple of tracks in our mental health court. One is as a diversion track, and one is basically as a condition of probation and or re-entry track. Individuals can come into our mental health court on a variety of offenses. And because there is no limit to the types of offenses that people diagnosed with a mental health issue have, the only limitation that we have charge-wise to our program is, unfortunately, we're not able to take sex offenders because of our state requires a special set of criteria for those offenders. But basically, we will consider anyone else for our mental health court. One thing we have is an objective checklist to determine eligibility. So that way we are not considering subjective matters to decide whether or not someone is eligible for treatment court, particularly mental health court. And once someone is referred to our program, we go through this checklist, and if they're eligible, then any of the judges in our circuit may order them in. The only requirement is that they live in the county, because the program is funded by county tax dollars. Once they come into the program, they go through a series of assessments with our community behavioral health provider, substance use provider. We run through some trauma screenings. They're paired with a psychiatrist, and then usually within the first 4 weeks in the program, we're able to have them with access to medication and a treatment plan. The benefits to the community are really vast. One is treatment courts, and particularly the mental health court, can kind of tip the scales when it comes to cost to a community, because obviously having someone in the community and doing well is much less expensive than incarcerating someone. Additionally, we tell everybody that comes in, now that you're hooked up with this behavioral health team, whether you're in mental health court or not, you will have ongoing access to this behavioral health team, and as a part of the community. And so we tell everyone that we want this to be your last contact with the criminal justice system. And if we achieve that goal, that's obviously a huge win. It's a win for the attorneys, because then they're not dealing with that high volume of cases. We have a public defender crisis in our state. We have jail overcrowding and prison overcrowding in our state. So these are all issues that we are using our problem-solving courts to attempt to resolve.
All right, thank you. The advantage of being the moderator of a panel is I can ask judges very difficult questions, which I otherwise might not be able to. So I'm going to ask you a couple difficult questions. The first is, people with autism spectrum disorders are often charged with sexually oriented offenses. And you said earlier that your court excludes people who are charged with sex offenses. Given that situation, if someone on the spectrum believes that, or the attorney believes that that person could benefit from your court, what can that attorney do?
Well, in our community, because of the community behavioral health access that they have, they can still provide a treatment plan to their client, even if they're not run specifically through the mental health program. So it's not to say that a treatment plan won't be available with community dollars. It just means with our model and with our probation officers that we work with, the criteria are just not going to be a good fit for our program. But certainly there is still a treatment plan that could be available with community dollars for those individuals.
Yeah. Just counsel has to take it upon him or herself to seek out what that plan might be and present it in a traditional court.
Yes.
Secondly, a number of defense attorneys are troubled by how many, if you will, hoops a defendant has to go through in a mental health court. And in particular, they say some clients with mental illness just don't have the discipline or the life skills to do it. How do you accommodate those defendants?
Well, I think that there's a lot of education that needs to continue with treatment court professionals. So that way we're not making the outcome worse for people who choose to come into treatment court. We're offered as an alternative to incarceration. And so we need to be mindful of that when we are working with our population. We also need to make sure that we're not making people give up more rights than necessary to be able to take advantage of a treatment plan and with medication. Having somebody prospectively waive certain rights just so that they can get access to treatment is not what treatment courts should be about. So we just need to really do a better job educating. And the National Association of Drug Court Professionals has standards. Each state is working on their own standards, and the courts need to follow the standards that are set in place so that the outcomes can be better and not worse for the people coming into our programs.
All right. Well, thank you for that, and thank you for the good work that you're doing.
I wanted to mention one other thing, Elizabeth,
Sure.
if I could.
Sure.
The American Psychiatric Association has a judicial bench card for judges to keep at their bench to recognize symptoms of someone in a mental health crisis. It's available to download online simply by Googling that document. And it's something that I've given to all of the judges in my circuit to keep handy, so that if you have someone who you believe may be experiencing a mental health crisis, a layperson can run through these lists of symptoms and be able to maybe triage that individual.
Sure, sure. And it would probably be a helpful document for prosecutors and defense attorneys as well.
Yes, thank you.
Okay, thank you. And finally, we are moving to attorney Jennifer Johnson. Jennifer was a longtime senior trial attorney at the San Francisco Public Defender's Office. She left that office a couple of years ago, but she did not leave without making her mark. She was one of the inventors of the mental health court in San Francisco. And now she is a consultant with a number of organizations throughout the United States, including SAMHSA. And she uses the depth of her knowledge and her experience in the Bay Area to help educate all players within the criminal justice system. So, Jennifer, my opening question to you is, jail and prisons, as Mark laid out for us, is often the worst place in the world for people with a mental disability. And now, because of the pandemic, it is a particularly bad place for people with mental disabilities, but indeed people with a variety of other types of vulnerabilities. What, if anything, can defense attorneys do during this time to help their clients who are incarcerated, if in fact those clients can't be released for whatever reason?
Well, that's a great question. And first of all, I just want to say, as someone who started a mental health court in 2002, I sure wish that you had been the judge and that you, Mr. Dupree, had been the DA in my court. We have evolved so far in 20 years in how we look at criminal justice reform. And I find it very heartening to hear how progressive, which may be a bad word, but how forward-looking you are on these issues. I actually was a public defender. I now work in the sheriff's office part-time, and I do consulting. And so I have a pretty close bird's eye view of the trauma that is going on in our county jails. And it's not just limited to the people who are incarcerated. It's also the staff that work there. It's the jail health services. It's the people that clean up. There's an intense fear that is clouding everything as it relates to COVID. At the same time, many people are being released from custody who in another day may not have been. And I consider that to be a good thing and something that I hope will continue. And as I've said to Elizabeth, I'm no longer a practitioner. I've moved away from that, but I do know that to help a client who's in jail, the most important thing is communication. The most important thing is being able to talk to them and to be able to tell them what is going to happen next, how it's going to happen, and to this gets into something that I think is a really important thing that I do training on, which is I train communities in what it means to have a trauma-informed justice system.
And what do you mean by that term, Jennifer?
So the people that come to us in the criminal justice system, as I always said, they don't have one problem, they have 15. And the rates of trauma among people all across the criminal justice continuum are absolutely astounding. men, among women, kids, and they're all various types of traumas, right? It could be abuse, it could be sexual abuse, it could be poverty, it could be neglect. It could be a community trauma like COVID, like we're experiencing right now. There are a million ways that people are traumatized, and they come to the criminal justice system with that as an underlying feature, not as it's so part of of people's existence. And the criminal justice system itself is a highly traumatizing place, as you said from the beginning. A lot of people that we work with have already been through the system many times. And so as a system, a trauma-informed justice system, how do we look at it from beginning to end? I don't know if you all are familiar with the sequential intercept model. If not, I highly
Again, tell us what you mean by that.
So sequential intercept model is created by Policy Research Associates in Albany, and it is a way of looking at the criminal justice continuum from the beginning to the end. Intercept Zero is that place where people, as Mark Dupree was saying, where you can get them out of the system before they even get in. Like, let's find out what to do before they penetrate into that system. And then as you go through intercepts 1, 2 through 5, there are various stages of the criminal justice system, and the idea is to look at that continuum and to ask ourselves, where along this continuum can we divert people out of the system and provide them with the needs, the things that they need to address the root causes of behavior. Ideally, we don't want them to get to intercept 5. That means they've been to prison. But many of the people we're dealing with have been there before. So they already have that underlying trauma. What a trauma-informed justice system would look like is having all the players at all of those intercepts understand fundamentally how people with a trauma history, that how they might be re-traumatized in a particular situation. And we know that behaviors, as Dr. Wood said, behaviors are symptoms, and those behaviors are just the tip of the iceberg. We may not understand why someone is screaming in the lobby of the public defender's office. It may be related to trauma. We just don't know. So how do we manage those behaviors as a system? If there's one place in the system that is weak, that is not using trauma-informed approaches to the people that they work with, then the entire system is at risk, because it's the weak link in the chain, and we can't have a weak link in that chain. So in this training, we talk to prosecutors, court clerks, the person that is at the front desk of the public defender's office, judges, lawyers, anyone who touches the system, to try to tell people, hey, the reason that this person can't have their back to the door is not because they don't like you or whatever. It's because they have trauma. So that's the idea of a trauma-informed justice system.
And you mentioned that you do trainings, but more broadly, how do you educate all members of the criminal justice system about a trauma-informed justice system?
Well, the trainings that we do can be targeted to a particular agency, or they can be targeted to a community where we have groups of all of those people interacting with each other. And that sometimes is the first time they've ever interacted with each other in that way. Mm-hmm. And I can tell you, it's a very intense experience. And what comes out very often is that a lot of people that are in the room also have trauma. And we can't forget, it's a topic for another day, but we are also very open to secondary trauma, vicarious trauma, and taking a lot of that on, and suffering from compassion fatigue. So we have to take care of ourselves as well. But I think when I just want to say, I'm really, so Elizabeth, you know this because we've talked about it. The American Bar Association, this is to speak to how this affects lawyers. The American Bar Association passed created their guidelines, the ABA guidelines on criminal justice and mental health, the standards. And I'm absolutely such a champion of those standards. I think they tell us, you have to do better. You have to do better as it relates to mental health, or you're not doing your job. And we haven't been told that before. So having trauma-informed attorneys is also really important, because as much as this is a systems issue, it's also an individual issue. Individually, as we interact with our clients, or the people that are in front of you as a judge needs to be trauma informed. A judge, I'm sure you know what the power that you have behind that bench to do good, or you could easily re-traumatize someone. And sometimes they're easy fixes. Sometimes it's as much as the public defender narrating from the holding tank to the podium, now I'm going to do this. The bailiff is going to cuff you from behind. I want you to be aware. Now the judge is going to tell you this. You don't have to say anything. Those kind of approaches. So we need to know trauma-based approaches on a systems level and an individual level.
It seems to all go back to what you said in the very, very beginning about communicating with your client, communicating with families, communicating with the victims. I want to ask you a question that some people have emailed in advance of this particular from families of my clients. Families get very, very frustrated. Families of people with mental disabilities get frustrated because they perhaps know their loved one's situation better than anyone else. And they try and convey the nature of the disability, the loved one's likes and dislikes, past history, past traumas, everything about that person, and they can't get a return phone call from the public defender. Sometimes they can't even get a return phone call from a private attorney. Can you talk to our listeners and any family members who might be listening as well about different structural barriers public defenders and private counsel have with communicating with family, and in turn, how a family might be able to get much needed information to the right place?
Yes. I think that's one of the tragedies of our criminal justice system, is that the waves of damage, the ripple effect of this system is wide. And especially as it relates to people with mental health issues, often families are the ones that are the victims. They're often ones that have been trying to hold this thing together and they can't. And they also won't give up on the person that is that they love. I mean, they can't. I've heard so many of the family members in my court would say, I'm so happy that so-and-so is in jail because I know they're not going to die tonight. It's a terrible, awful situation. And the criminal justice system can re-traumatize those victims and those families just as much. I think we live in an adversarial system. We cannot deny that. We have collaborative courts, but at our core, the criminal justice system is adversarial. And I think that has done damage in terms of how we treat the witnesses and the people that are in the courtroom. I think we have to do our best job to listen. And that goes to those standards, Elizabeth. Really, they're telling lawyers, you can't just put this under the carpet. You can't ignore the needs or the information that family has. It's vitally important. I think that public defenders and DAs are crazy, overwhelmed, busy. It's a ridiculous thing that we ask of the lawyers. So I understand that, and some empathy around how difficult that job is coming from the family members might feel a little less personal when they don't get that call back. One new development in offices, both both public defender and district attorney is the addition of social workers. And the social worker, I think, could be a very, very good bridge. Number one, they know how to talk to people. Number two, they understand the value of the information. And number three, that information is not just valuable to the family member, but it might help in a case. You may not know that the person suffered trauma because they may not talk about it, but it may be essential. So I think we as a system have to do a better job of opening up to what it is the family members and friends and that information that they have, because the more we know about a person in the system, the better we can individualize a treatment plan. The better the treatment plan, the better chance they have.
Sure, sure. And at the same time, there are issues of privacy and confidentiality that come into play, and certainly issues of privacy when the defendant is over the age of 21 or over the age of 18. We've heard from all four of our panelists. I know that Casey Clevenger has to leave momentarily. So we thank her for her reviews, but we've had a number of questions to be submitted to us. Some of them deal with rather personal situations, and we have an ABA policy where we can't address individual cases, but certainly those individual cases raise very interesting issues, and hopefully those can be addressed in some sort of way during the question and answer period. Maybe they've already been answered during the course of the panel. The first question is for you, Dr. Woods, as well as you, Jennifer, because I think you both have good perspectives on this. What is to be done about a defendant who just does not have any insight into his or her mental disability, does not want an evaluation, does not want to go through treatment court, in fact, just wants to do anything so he or she can get out of jail and get the charges to go away as quickly as possible? And in particular, what are family members to do if they know that that person has a long-standing history of mental illness, but of course puts on his or her best face when meeting with the attorney, maybe even meeting with the mental health expert?
George, Dr. Woods, you're on mute. There you go.
Is it showing me?
There you go.
Okay. Let me jump on that for a moment. And as I went through the questions, I looked at them quickly, and I think there's a broader issue that I want to address, and then speak to the more specific issue. The broader issue may be somewhat heretical, and I apologize for that, but I think it's important for both sides, the prosecution as well as the defense side, to move away from using forensic experts. I think that when someone is defined, as I often am, as an expert in forensic psychiatry or forensic psychology, that doesn't speak to their ability to help you understand your client. That really speaks to what they may know about the courts, but it doesn't tell you anything about their expertise in psychiatry or psychology. And when you have a team come to you, as you mentioned here, Elizabeth, with someone that is in denial, it's really important for you to understand where that denial comes from. Is that denial secondary to a significant cognitive deficit? Is that denial secondary to psychotic disorder? Where does it come from? And if you don't have someone that can help you figure out where that denial comes from, then you're caught, because you're not going to be able to get to the root and figure out a way to approach it. You know, different types of denial can come from different places. And you have to be able to have someone that can talk to that person, can understand, do they not want to have that experience because they've been traumatized and they don't want to relive that experience? Do they not want to have that experience because medications have not worked for them in the past? Which I was on a presentation this morning at Harvard, a continuing education, where they talked about the fact that, you know, medications often don't work. And when someone tells you that, you need to pay attention to it. So you can't answer that question if you don't have someone that can help you get to the root of why that person is in denial.
All right, Jennifer.
I would add, as a from a practitioner standpoint, in the meantime, until you know what the root of that denial is, you have to manage it still. And managing somebody who doesn't have insight is a very difficult thing. And there are things that Dr. Woods and I teach a class together, and we teach one of our classes is called Listening to Mental Illness, and it's about listening to what the person says, not denying that they, not sort of negating delusional thoughts or telling them, no, you do have a mental illness and you have to take medicine. It's more of an approach that is not confrontational. It's how do you partner with that person and say, okay, we agree that you don't want to go back to jail. I know you don't want to take your medicine, but you also don't want to go back to jail. So those are kind of the options. That's what I did as a practitioner, was to take it away from any sort of judgment and really make it a sort of cause and effect question. So, which may not be the way that Dr. Woods would recommend doing it, but you have to manage a very difficult symptom, which is lack of insight.
Sure. And Dr. Woods, isn't there a medical term for lack of insight?
The medical term is anosognosia.
Could you say that slowly again?
Anosognosia, right, without thought.
Yes.
Right. And there are probably 30 different pathways that can lead you there. It could be just denial. It could be a problem on the right side of the brain. It could be a negative symptom of schizophrenia. There are so many different ways that you can get there. So you don't want to lump it all together. And I do agree with Jennifer that you have to manage it. One of the ways in which it's very difficult for attorneys, particularly public defenders, is to spend time with your client. And when you mentioned, or I think you even mentioned social workers, you know, having these ancillary team members that can spend the time with your client to develop some modicum of trust, because trust cuts across all barriers. And if you can develop some modicum of trust, you'd be amazed at how it will speak to that denial.
Mm-hmm. But trust is earned between an attorney and a client, or between a prosecutor and victims and victims' families. Mark, I'm going to turn to you for the final question. We've had a number of questions in the queue about juveniles charged with crimes. Sometimes juveniles charged with serious crimes. And one of the most intriguing questions to me was submitted by someone who wants to know how young is too young to be charged with a crime?
I tell you, I think that there's been many books and studies written about that. And I think it goes down to specifically each prosecutor. I was a defense lawyer for nearly a decade before I became a prosecutor, and the youngest that I defended was an 11-year-old who was accused of a serious crime, and the prosecutor was considering waiving him to adult. And of course, gratefully, it was not able to happen, but it was a conversation. And so I think well, I know it literally falls in the hands of the discretion of the district attorney. I personally believe that we have to follow the science. We have to follow what the research say, and we know that young folks are continuously developing in their thinking and in their minds, nearly up to age 25. And so when you're dealing with individuals who are committing crimes as juveniles, I think that all of that needs to be taken into consideration with determining what the charge should be. Sadly, I can't give a direct answer. I promise I'm not trying to pivot or avoid, but it specifically is case specific, and it depends on the facts of that case. And now here's the catch: just because a child or a juvenile is charged does not mean that you don't take into consideration all of the age and lack of maturity with trying to figure out a disposition.
All right, thank you for that. Well, that will have to be the last word, but thank you to all three of you, as well as to Commissioner Clevenger, who had to leave early. Thanks also to Patrice Payne of the American Bar Association with helping us facilitate this panel, and of course to Kim Parker, the chair of the ABA Criminal Justice Section. I know all of these people have their bios available online, as well as contact information, and I'm sure that they would be happy to address any additional questions that you might think of afterwards.
Thank you.
Thank you for this opportunity.
Thank you all.